Have you ever stopped to think about how the law actually keeps up? I mean, with things like AI exploding or completely new questions about human rights, how does it adapt? Well, the answer is this amazing story about arguments, predictions, and a trail of hidden clues. And today, we're going to follow that trail. Okay, so this is the central problem, right? Put yourself in a judge's shoes for a second. You're facing a case, and there's nothing like it in the history books. No clear law, no perfect precedent. The rule book is just blank. So where do you even begin? It's not like they just make stuff up. No, there's a process, and it's actually pretty cool.
So, first up, we have to deal with this constant flood of unanswered questions. Because let's face it, the law can't just be some dusty old book on a shelf. It has to be a living, breathing thing that adapts. Otherwise, it just becomes useless.
So what's your guide in all this uncharted territory? It's this, the Law Journal. You can kind of think of it as the official research and development, the R&D lab for the entire legal profession. To put it simply, a law journal is where the really deep, heavy thinking about the law happens. It's a collection of articles from legal scholars, professors, and even law students, all wrestling with these super tough problems. They analyze the law, they criticize it, and they even propose what the law should be. And their importance is huge. These are not just some stuffy academic papers. They spot trends way before they become headlines. They come up with powerful arguments that lawyers actually use in court, and judges will literally cite in their decisions. They're an absolutely crucial tool for keeping the entire legal world sharp. And you know, they come in all shapes and sizes. You've got your big general law reviews that cover a bit of everything. But you also have these highly specialized journals that are laser-focused on one single area, like environmental law. There are practical journals for working lawyers, and even journals that get super philosophical about the very idea of law. Seriously, for almost any legal question you can dream up, there's a journal for it.
So we know what they are, but how do you actually use one to find answers? Well, this is where you put on your detective hat. It's all about following a trail of footnotes to find the most important clues.
The whole process is really an art form. I mean, sure, you start with a simple search, but the real magic begins when you find a good article. You check out the author, of course, but most importantly, you dive into the citations. That author has already done all the hard work for you. They found the key court cases you need to know about. And this gets us to the most overlooked part of any legal article, the footnotes. I know, they look so boring, but trust me, they are the treasure map. They're your roadmap. They point you directly to the key cases, the laws, the foundational arguments. This is where the real investigation begins.
Okay, so you follow those footnotes, and they lead you to a major court case. But what you find there is rarely a simple yes or no. What you really find is a debate. And understanding that debate is the key to understanding how the law works.
The most critical thing to get here is the difference between the majority view and the minority view. The majority opinion, well, that's the winner. It sets the precedent. It is the law. But the minority, or the dissenting opinion, that's the prophecy. It has no legal power today, but it's an argument for what the law could be tomorrow. It's a powerful voice saying, I think you all got this wrong, and here's why. And just to give you the complete picture, sometimes you'll also see a concurring view. This is basically a judge saying, look, I agree with the final result, but I got here in a completely different way. And that's really useful because it helps clarify exactly what the new rule means and, just as importantly, what it doesn't mean.
And this is where it all comes together. That dissenting opinion, the one that lost the argument, the one with no power, often ends up having the biggest impact in the long run.
A dissent is like a powerful spotlight. It shines a bright light on all the logical flaws and the potential problems with the majority's decision. It's the official record of a brilliant counterargument, just sitting there, waiting for its moment. And this really gets to the true purpose of a dissent. See, it's not just an argument with the other judges on the court. It's an argument with the future. It lays out a complete blueprint for how to change the law, just waiting for the next generation of lawyers and judges to come along and pick it up. And often, that's all it takes. Just one powerful dissent, picked up in those law journals we talked about, debated by students, and it can begin the slow, steady process of turning a losing argument into the law of the land. So, the next time you hear about a major court decision, don't just ask who won, ask who dissented and why. Because in that dissent, you might just be reading the first draft of the future. Which leaves us all with a fascinating question. What losing argument today is just waiting for its moment to become the winning argument of tomorrow?